A very good day to everyone. For today's tutorial on business law regarding negligence, let's have a look at some of the legal writing skills that will be required to answer the problem question. So we know that to become an advisor for business context, there is a need to know about the knowledge and legal theory, legal writing and communication skills, research and analytical skills, understanding of commercial intent, as well as the drafting ability. At this point, I will not be looking at the negotiation skill because it is not directly relevant to either your syllabus or your written assignment or final examination question. So I'll be looking at number 1, knowledge and legal theory, 2, legal writing and communication skills, 3, research and analytical skills, as well as understanding of the commercial content, what the parties want from that particular scenario, and your ability to draft sound advice. So, as you already know, we are not born to know a certain skill, and it takes time to learn. And I'm hoping that you will already have started to take the initiative to do some exercise on your own. So effective legal writing techniques can actually be learned, and it is crucial to know how to structure a proper argument and to present the information in an effective manner. So when answering essay and problem questions, such as the one that you are gonna do either for your tutorial question outline or your written assignment, you must analyze the question and write strong, effective, and well-structured argument in response, or you're supposed to give advice in that manner. What is an argument? An argument is a series of statements and usually backed by evidence, and usually you're supposed to prove or disprove a given position. An argument is a journey from problem to solution through interpretation and application of legal rules to a legal problem or a given scenario. And sometimes to solve problems with rules, you require some creativity and imagination. What are legal rules? We already know that legal rules can be oral or written statements guiding the conduct of individuals or groups, infringement of which may or may not result in compulsory or discretionary action. It could actually represent a view of a group of concerning lawful, moral, social, acceptable, and good action. And also, you must already be able to know that for negligence, there are several elements to be shown, such as duty of care, breach of legal duty, consequential losses. And also, there are some possible defenses available to the defendants. What is logic? It's actually a science of reasoning, thinking, or proof or interference. For a lawyer or a legal advisor that you put yourself into the moment when you're doing business law, logic is actually to study the propositions and how conclusions may be correctly obtained from propositions in the process of a reasoned argument. Right? You must not try to contradict your own argument. So for instance, if your argument says that point A and point B has been proven, and therefore it's likely that there is actually the outcome that is successful, but in your conclusion you say otherwise, this will not show that there is a logical flow. In addition, there is a need to draw analogy in support of your argument, and it is one of the most common form of argument in law. It begins by stating that two objects are observed to be similar by a number of attributes. And it concludes that the two objects are similar with respect to a third attribute. And the strength of such an argument depends upon the degree of relationship. So usually judges are involved in the type of inductive reasoning that is called reasoning by analogy. This is a process of reasoning by comparing examples. The purpose is to reach a conclusion in a novel situation. So the process by way of reasoning through analogy has 3 parts. Okay, the similarity between the cases that is observed, the rule of law or the ratio decidendi inherent in the first case that is stated, and the rule that is applied to the case for decision. All right, so it's from general to the particular, which is called induction, and particular to the general through deduction. So one of the ways to answer problem question in a structured way is through the CLEO method, which is first identify the claims and issue, to present the applicable law, and to evaluate the facts, and lastly, to identify your outcome using proper argument. So for instance, if a particular scenario involves a car crash and party A is injured by party B, so in this context, the claim will be on compensation through negligence, and the applicable law will be on the notion of negligence and what are the elements to be shown in order to demonstrate negligence. And thirdly, based on the facts given in a car crash situation, whether or not the duty of care exists between party A and party B as road users, whether there is any breach, and also if there is any loss suffered by one of the parties. So you need to use the case laws such as Donahue and Stevenson, such as Paris and Stepney, such as Latimer and AEC, so on and so forth, in order to evaluate the facts using those laws. Lastly, you should be able to provide a possible outcome, whether or not one of the parties will be successful or there are some potential defenses which could actually affect the success rate of the outcome of the claim. So what are the elements of a first-class argument? First, there is close attention to the question as it is asked. So if the question talks about a car crash situation, but in one of your answers you say there is a motorbike that is involved, surely the examiner will notice that there is no close attention to the question that is asked. And we can avoid this by preparing earlier and not to do whatever work in the very last minute. All right, details knowledge of the topics addressed, also the deeper understanding of the context, will also award you a first-class argument. Some superlative coverage of the question, including accurate demonstration of the law and application of the law with no or almost no significant errors or omissions, will also be awarded with a first-class argument or grade. And if you're also able to identify at least some of the less obvious points, will be very good as well. It shows that you are able to appreciate the law in a proper way based on the context given. So what are the features of a first-class answer? There is outstanding clarity of structure, argument, and writing style, excellent use of support information and ideas, use of more than one possible line of argument, presentation of the theoretical arguments concerning the subject, significant critical analysis, and thoughtful personal perspective on this particular debate or advice. But knowledge is one of the most key important features to show the first-class answer. So through knowledge, if you're able to read and to digest, that will be one of the best ways to demonstrate in your answer. So step 1 in the CLEO method, you need to identify the claim and decide what points you need to make to answer the question given. Spot some of the legal controversies and construct multiple lines of argument and respond to questions as they are asked. And write a 2 to 3 sentence opening paragraph when you can set forth the claim quickly. All right, so for instance, If you know that the claim is on negligence, then you give a brief definition of negligence and what elements to be shown and what are the possible defenses available to the negligence claim. And you need to be able to use laws such as Donahue and Stevenson to support this particular part. And present the most applicable law is step 2. You need to identify the applicable legal authority and demonstrate the depth and breadth of your legal knowledge. And try to find the best case which is available through either your slide, your textbooks, or some online resources which demonstrate the current and accurate and reliable law on Malaysian law, on also the English law, and possibly also Singaporean law. So you can find the leading case and the most specific case and the most factually similar case which is applicable to your scenario that is to be advised upon. So further step on the elaboration of the law is to begin with the general rule associated with the claim and move to the general rule associated with the sub-issues, and also set up your specific exceptions to the rule and any cases you need to distinguish, and relate more specific cases to the general standard. All right. Thirdly, you need to see also what are the facts and evaluate the facts in light of the legal authorities that you have mentioned in the second step. So illustrate your powers of analysis and persuasion as you discuss the extent to which the facts in your particular question live up the general legal standard identified in the discussion of the law. And there is a need to demonstrate some originality in your thinking and writing style. Crucially, apply the law to the facts of your case and explain the importance of each of the legal authorities to your specific fact pattern. So in step 2, in slides 13 that I've mentioned earlier on, you will need to provide already an objective analysis of the standard that is applied to all persons and all situations, and you provide a factual analysis of your problem and discuss the issues that are primarily in dispute. And track your legal analysis and demonstrate how the facts apply to each of those standards. So start at the beginning of your law section, analyze how your facts demonstrate the non-contentious issues, focus on the contentious issues, and briefly mention some of the minor issues. For instance, it could be related to also occupier's liability, it could possibly be related to vicarious liability, it could also be related to some other minor issues which can bring about some effect to your analysis. And most importantly and lastly, identify the outcome of your argument. So if, let's say, in your argument you said elements on duty of care, breach of duty, and consequential losses have been demonstrated, and there are no possible defenses available to the defendant, then in your outcome you will say that in conclusion, the claimant's particular compensation will prevail and he or she will be able to receive damages in certain amount. You don't have to give me a figure, but just say that they're able to claim damages based on your analysis. All right. So it is crucial that you need to indicate that how the court would have resolved this particular issue. All right. And you need to indicate who will win this particular scenario based on your argument. All right. Let's also make sure that it is crucial you answer the problem that is being asked. All right. And you are able to present clearly, identify legal authority, true cases, and also use legal arguments. So, brief recap, the structure is actually has to be clear. So this is an example of a problem question in tort, which the source is from ACCA Global, the Malaysian part of it. So in this particular simplified scenario, Harry is involved in an accident in which his car is hit by one driven by Alex. As a consequence of the accident, Harry breaks a leg and is unable to work for 2 months. Can Harry sue Alex for damages? So we need to identify who the parties here. Harry is the victim and he's got hurt. And he would like to claim from Alex, who is the potential defendant. And Harry, we know that he breaks his leg and he was unable to work. So we need to advise Harry, who is the victim or the claimant here, whether he can sue and using which law. So first of all, you do your introduction. Okay, so this particular sample will give you 12 parts from the beginning right to the end of a particular work that could be a minimum requirement to give a proper legal advice. All right, so first you will explain the tort of negligence is a legal wrong that is suffered by someone at the hands of another who fails to take proper care to avoid what a reasonable person would regard as a foreseeable risk. So in order to prove negligence and claim damages, a claimant has to prove a number of elements to the court. First of all, the defendant, who is Alex here, owed them a duty of care. So defendant Alex, we have to show that he did owe a duty of care to Harry. And secondly, the defendant Alex breached the duty of care. And thirdly, the victim suffered loss or damage as a direct consequence of the breach. So even if negligence is proven, the defendant may have a defense that protects them from liability. So we need to identify these parts. So what is the duty of care? So part 2 of the outline for this particular answer will be to explain what is duty of care. So you explain when it was created. It was created in the case of Donahue and Stevenson. So the House of Lords states that every person owes a duty of care to their neighbor. The Lords went on to explain that neighbor actually means a person so closely and directly affected by my act that I ought reasonably to have them in contemplation as being so affected. And you can also use some later cases such as Enns and Merton London Borough Council and Caboro Industries Private Limited and Dickman to explain the meaning of proximity and fairness. You can also use some of the cases which have been given to you in the slides or given to you in the textbook based on the concept of negligence. So you explain what is proximity. This is the part where you explain about the law. The part in red will be on the evaluation of the facts. So here the evaluation is that Alex owes Harry a duty of care because there is sufficient proximity, and it is reasonably foreseeable that a collision between cars could cause Harry some injury, and it seems fair, just, and reasonable for Alex to owe a duty of care to Harry, all right, and general duty to other road users. So we have established that there was a duty of care. Second element is that Alex breached his duty of care. So it's crucial that the standard of care has been met by the defendant. So the standard requires actions which the court considers a reasonable person would have taken in those circumstances. If the defendant or Alex failed to act reasonably given their duty of care, then they will be found to have breached the duty. So the actions that the defendant took are in line with common practice or industrial recommendations. This is more to do with professional negligence of their duty. If they were, then it's likely that the defendant would have met their duty unless the common practice itself is found to be negligent. So also if there was some social benefit to the defendant's action, then it is unlikely that they will be found to have breached the duty. And if the defendant's action had a high probability of risk attached to them, and it is to be expected that the court will want them to show extra precautions to prevent loss or damages. If they fail to do that, there is a likelihood that they will be found to have breached their duty. So as you can see here, if professionals will actually use their proper reasonable care in their line of work, and these are guidelines that have been followed, then it is likely that these professionals will not be found in breach. So you will need to use also case laws to support your answer. All right. So in this particular sample, in the case of Harry and Alex, this is the application and evaluation part. In determining whether or not Alex broke his duty of care, a court will consider whether or not, given the circumstances, he drove as a reasonable person would behave. For example, it was unclear from the facts that if there was any fog or if the floor was wet or the road was wet. If, for instance, they were foggy or wet, he would be expected to show that he did drive cautiously. So in determining whether Alex's actions were reasonable, evidence may have to be taken from witness and expert analysis. So let's now assume that Alex was not driving reasonably. And there are some extraordinary situations where res ipsa loquitur will be claimed, where the facts may be so overwhelmingly in favor of the claimant and the court decides the defendant should prove they were not negligent. You can see here the meaning of res ipsa loquitur means the facts speak for themselves. It applies in circumstances where the cause of the injury or loss was under the control of the defendant and the incident would not have occurred if he had taken proper care. And it is more often applied in medical cases. For instance, in Mahon and Osborne, a surgeon had to prove that he was not negligent to leave a swab inside a patient. So the third element is to be shown to provide a strong justification for negligence. It is on the loss or damage as a result of the breach. So the claimant must prove that the loss or damage in the form of financial loss or physical injury or property damage was a direct consequence of the defendant's breach of duty of care. So, in other words, there is a chain of causality from the defendant's action to the claimant's loss or damage. So, a simple test called the but-for test is applied. And the claimant has to prove that if it were not for the action of the defendant, they would not have suffered the loss or damage. Where there is more than one possible cause of the loss or damage, the defendant will be liable only if he can prove that the action is the most likely cause. So for instance, if a car crash happened and the victim was sent to the hospital and he died as a result of the hospital's failure to provide proper first aid at the right time, there is a possibility that there is a possible break of chain of causation by the hospital instead of the original car driver who caused the crash. And a good case which illustrates how the but-for test is in the case of Barnard and Kensington Hospital. So a casualty department negligently sent a patient home and the patient died. However, the doctor was not found liable because the patient was suffering from arsenic poisoning and would have died irrespective whether or not the doctor was negligent. In addition to the causation or the but-for test, the second part to be shown for loss or damage is that those loss must not be too remote. All right, and it's crucial that people should be liable for losses only when they have reasonable reason to foresee those potential outcome of those actions. And the case law to be used is the Wagon Mount case. All right, and in this case, the oil leaked out of the defendant's boat within Sydney Harbour and came into contact with some cotton waste, which had fallen into the water. The oil was of a particular type which would have not caught fire on water, and the cotton ignited and set the oil ablaze, causing damage to the claimant's wharf. The defendants were not liable for fire damage as the actual cause of the fire was too remote. It's totally unforeseeable. So towards the last three parts, so you need to evaluate the facts based on the law that you have just demonstrated on the loss of damages. So let's return to Harry and Alex. It is entirely possible for the accident to be caused by a third party driving into Alex. And there is also a likelihood that Harry himself could be an intervening factor, which is unclear. So you can actually mention that since the fact is unclear, if really Harry was driving erratically himself as a victim, then it's possible that there is some kind of element of contributory negligence. All right. So let's assume that no third party is involved in any action Harry took are actually not enough to take the blame for the cause. And if that happens, then the court will find Alex liable for negligence for the injury of Harry and his inability to work for 2 months. Don't forget also to talk about the possible defenses available for negligence claims, such as in the case of Harry and Alex that we are trying to advise here. And there are 2 defenses that Alex could possibly use, all right, if they are or he is found to be negligent. Voluntary non-injuria will exonerate complete or is a full defense, whereas contributory negligence is a partial defense where the level of damages will be reduced. Involuntary non-injuria means that voluntary acceptance of the risk, and if the defendant can prove the claimant accepted the risk, they will not be liable. Acceptance can be expressed using a consent form or implied through the claimant's conduct, whereas contributory negligence takes part of the blame or fault away from the defendant if it can be proved that the claimant contributed in some way to their loss or damage, and the defendant could still be liable but will face a reduced damage payout, meaning that the claimant will be able to get less from the compensation. So this is the law part on defenses. So move on to the evaluation of facts. In Harry and Alex's case, voluntary is not actually an issue, because how can Harry consent to being hit by the car? However, if his action contributed in some way to the injuries, it could be that he was not wearing seatbelt, or he himself was speeding excessively, then he may find the amount of damages he received is reduced. So towards the end, we need to clearly give an outcome in the form of a conclusion. What is your advice? So is it likely that the court will find Alex liable? Probably yes, as all 3 elements for duty of care, breach of duty, and consequential damages could be shown. However, it seems that there is no defense, there's no voluntary non-injuria or contributory negligence is shown. And as a result, we can conclude that Alex must compensate for Harry, as he was injured from the negligence of Alex in driving onto his car. I hope this session is helpful for you to complete both your tutorial question as well as your written assignment. And please, if you can look at the tutorial question, what is for this particular week. As you can see here, the questions involve also negligent question. So do have a look at question 1 and 2 of tutorial for this particular week. Under law of tort. Alright, so question 1 is that Alice has been suffering from low blood pressure and on several occasions she has fainted as a result of her condition. One day, while driving back from work, she fainted at the wheel of her car and collided into the car in front of her. The driver of the car, Bernard, sustained a broken leg and a number of broken ribs. Bernard's son, Charles, who was seated on the passenger side of the car, suffered internal injuries. Unbeknown to anyone, Charles had a rare blood clotting condition and suffered massive internal bleeding, and he died on the spot. Bernard was taken to the nearest hospital. Unfortunately, due to an administrative mistake, his left leg was amputated. Advise Alice of her potential liabilities. The second question. Christy has been feeling rather lethargic and unfit, so she signed up with the gym in her neighborhood called Gorgeous Shape and Fitness Center, GSFC. She was attracted by claims made in the brochure that gym is equipped with state-of-the-art facilities and has highly qualified gym instructors. Christy arranged for her first training session. She went first thing in the morning when the gym was open at 8 a.m. Being the first session for her, the usual practice for the gym was to assign an instructor to personally provide an 1-hour training session, as well as teaching her how to use different facilities in the gym. She was asked to wait while they assigned a personal trainer to her. After waiting for about 10 minutes and being a little restless, Christy decided to try one of the machines on her own, as she did not think it would be that difficult to use the equipment. Dexter, who was the last user of the equipment the night before, he actually adjusted the height of the seat but had not fastened the seat back properly. When Christy sat on it, the seat, which was loose, if she fell off. She sprained her right arm when she tried to break her fall. She got up rather angrily and was walking towards the counter to complain when she slipped on the wet floor, which was just mopped by GSFC's employee, Elmo. Christy suffered from a head concussion from the second fall. She had to be hospitalized for a week as a result of her injuries. Advise Christy on her course of action on the tort of negligence and the relevant party or parties to sue. Give your assessment on whether Christy can successfully claim for compensation for the injuries suffered and discuss the practical obstacles faced by her in the lawsuit. Support your answer with relevant case authorities. So using the previous techniques, Cleo, and some of the example using cases, please provide me and email your outline of answer, maximum 1 page. All right, and you can email to me by the 22nd of September, which is this coming Sunday. If you have any question, feel free to email me as well, all right? And you can also meet me for consultation for your written assignment, but as mentioned during the lecture, I will not be able to receive any request for consultation after the 6th of October. All right, thank you very much and have a good day. Thank you.